Okay, guys, let's dive in. It looks like it's slowing down. Some people are still joining, but let's dive in here. Welcome to our 2026 legislative update webinar. This is a chance for us to review some of the changes that have occurred in Utah state law that impact our industry. We appreciate you taking time to attend. We're excited to present on these topics and are prepared to answer questions that come up. Quinn Sperry, who's serving as a co-chair on the LAC, has agreed to kind of help monitor and moderate the questions that are coming in. So if you do have a question, you can follow the Zoom icons and drop it in the Q&A section so that we can monitor those and make sure we get your questions answered if we can. We appreciate also the other panelists here. We've got Todd Bean, Ryan Bonham, and Bruce Cutler, and myself that are all prepared to present on various topics of legislation. And we'll take that in turn. But I first wanted to explain a little bit the dynamics of the legislation that was adopted this year. There are three or four bills that we'll be covering and a quick update on some changes to federal law as it relates to FHA financing and condominiums. Now, SB 122, it evolved. It was there from the very beginning. It was Senator Harper's bill, but I've got it grouped up here with Representative Walter, who had his own bill, HB 406, that towards the end of the session, as it became apparent that it had not progressed enough to get a vote from both the House and the Senate, a deal was made between Representative Walter and Senator Harper to take the substance and content of Representative Walter's bill and to put it in SB 122. So if you're confused, if you remember well from what we presented on the forecast last time, the reason we're not referencing Walter's bill is because it got swallowed up and folded into SB 122 with Senator Harper. After it got folded in, with the assistance of Senator Harper and others, we were able to do some substantial revisions and negotiations, and we feel it resulted in a much better bill that ultimately passed. So we'll be covering a lot of topics under SB 122. We're going to be covering also HB 306, which dealt with reinvestment fees. That was Representative DeFay and sponsored by Senator Collimore. And then there's some kind of more minor topics in HB 215 and 591 related to landscaping restrictions, nuisances, and the wildfire urban interface. And so these are the topics we're going to cover. To get started, though, we're going to have Ryan Bonham cover a few of these topics from SB 122.
Perfect. Okay. Our first one has to do with the administrative setup fee. This is the one that if you were involved and know about it, with the many discussions and a lot of the work that was put in with many different visits. Ironically, it kind of ends up being very simple. But to me, a heavy amount of workload and lift was put into this. There's a new definition that was added, and it's this first section, administrative setup fee. It's defined as a fee charge or payment that's related to the sale of property and as a result of the transfer of the real property imposed by buyer or seller by a common interest association or a person. In this case, a management company is kind of the default that does that, but on behalf of the common interest association. So these are the fees charged within the industry. There's really three main vendors that do this: HomeWise Docs, Get Docs Now, and Condo Certs. Also, some companies do it individually and separate from those third parties, but these are those fees for administrative setup charges. The portion of the law that restricts it, there was a restriction that was being posed to limit the dollar amounts that we opposed as a LAC, and that didn't pass. But what did pass was that a fee on or after May 7th, 2025 is void and unenforceable unless an association uses the fee only to pay expenses related to the transfer. In other words, the association can't profit off of that fee. They need to be related to actual expenses, usually management company expenses. And then the management company, as of the end of each year, needs to provide a report So if the manager collects an administrative setup fee, the manager needs to report back to the association, to the board, an annual accounting of each administrative setup fee that is collected throughout that year. The issue that this addresses is the representative was very concerned that the board didn't know how much money was being made, and they're the ones that have the oversight of the contracts where that's negotiated, and this resolved that issue where we were able to whittle down the concerns, the legitimate concerns, to being, well, the board needs to know how much is being charged, and that was kind of the settlement of the entire conversation. I miss anything there with those panelists, Tyler? I hit everything. Feel good about that?
Yeah, I think that's good. I mean, I always kind of beat this drum, but since we have such a good group of managers on, I think it's a reminder to us that um, outlier stories, exception cases lead to adverse legislation. So I think it's worth it just to mention, we ask you to really examine the work that you put in and the fees and to make sure that you're being reasonable and upfront and that associations understand and appreciate what goes on. We feel like when people understand all the work that goes into this process and the structure of your contracts, that we can head off some of this adverse legislation. Is that fair?
Yeah, 100%. I think the big takeaway and exactly what Tyler's saying is we should be paid for services we're rendering, but not gouging people. And that's the concern, is about gouging, being reasonable about the fees we're charging and making sure we're being paid for the work that's being done. As we discuss these with legislators, they're not debating that we should be paid for the work we're being done. That's kind of not the issue. It's when not having all the parties at the table to negotiate a fair rate and that one side's taking advantage, that leads to those discussions. And exactly what Tyler's saying. So make your money, be profitable, but don't gouge, right? Is the big takeaway there. And that helps us with passing good laws.
Awesome.
Great. Next slide. This is one that we were interested in. We had several of our communities and boards that were frustrated with the removal of parking restrictions that could be passed within a community. And so we were able to get this in at the last second. The highlighted yellow is the change in this one. Last year they restricted to where OHV and boats and other things couldn't be found in violation of governing documents. They had to be allowed to be parked on driveways, and some of our communities were upset that in their CC&Rs even it said that they couldn't drive those. So those are back in to where in the governing documents, in your rules particular, you can allow or you can restrict trailers, off-highway vehicles, boats, and this special mobile equipment is like tractors and other things if you go look at that definition. And so it's like farm machinery and other equipment that isn't allowed to be parked in driveways, and can be screened or other things behind a fence. So that's now allowed again. Last year it was restricted from enforcing, it is now allowed to be enforced by the rules.
Yeah, that special mobile equipment was intended to address things like Kubotas and Bobcats and forklifts and things like that we often see stored and parked in front of a house. Some people complain for excessive amounts of time.
Yeah.
Awesome.
Uh, we had a question and about a reinvestment fee, and I'll hit on that really quickly. That comes into the definition. This does not change the reinvestment fee rules. So this is an administrative setup fee, is not a reinvestment fee. Those are different things under the definitions. Um,
I think can I explain real quick what I think some of the key differences are there?
yeah,
Some of the key differences between a reinvestment fee and an administrative setup fee is that a reinvestment fee has many more uses that it can be applied to. It can be used for really virtually any association expense, whether that's funding your reserves, your operation, even capital improvements. Some developers even use those for infrastructure build out and things like that. Administrative setup fee is much more narrow in scope. It really only deals with getting somebody set up when they move in or out of the HOA. And administrative setup fees are also different than a reinvestment fee in that that money is allowed to go to a third party, like a professional community association manager or a service that provides disclosures or information at closing. Whereas a reinvestment fee any money that's collected on that has to be collected by the association alone. It can then be paid out to others for legitimate services provided, but those are the key differences. Is in scope. Administrative setup fees are just related to setting somebody up when they move into an HOA. A reinvestment fee can be used for all kinds of purposes, any legitimate association expense. So those are the key differences.
And Tyler, on that, I think you addressed it. There is another question that touches on that as far as if the HOA collects a reinvestment fee, can part of that go to the manager? So you were saying it can go to part of a third party. So just for further clarify that, if an association does not charge an administrative setup fee and they only charge the reinvestment fee, then the HOA can collect that reinvestment fee and then they can use part of that to pay the manager, who under their contract gets to collect, a fee for setting up a new owner. They just so they it's just an indirect way to pay that administrative setup fee without it being an additional fee to the owner. So
Awesome.
there is another one. Okay, looks like you're there. Yeah, somebody asking for the parking rules. Okay.
Good. Think we're ready for you, Bruce?
Okay. First of all, I want to just thank Tyler and others who spent a lot of time on Capitol Hill during the legislative session and did a lot of effort up there. I know Tyler and others who've been up there. I just want to thank them for all of their efforts and all of their hard work, because it is a lot of work and takes a lot of effort to get up there, and appreciate them doing that. And this Legislative Action Committee, I think, is probably the most important part of your Community Association Institute. The things that happen really protect homeowners and others because of the great work that is being done on this committee. And I'm just kind of one small part, but I want to thank those that put a lot of effort into it. So I'll go to the next slide. So I'm going to be talking about the Ombudsman Office. I will mention that the reason I ended up on this committee is initially I had contacted my legislator and thought, wouldn't it be great if we had an ombudsman with the state? And I was convinced that there can be other ways to do this, but this Ombudsman Office did come about. And now I can say, there's pros and cons, as there is in everything. And so the Ombudsman Office now is composed of 3 people, and the Ombudsman Chair, and then 2 others who work there. And there are some things that needed to be changed this year with some new law. The first part is actually some of these were already happening, but they now put them into law. Office shall make public each advisory opinion. That actually started to happen right away when they did it. So those opinions are all available on their website. We're going to talk about kind of a summary of those a little bit later. And in the office is to provide a list of statutes and frequently asked questions. I think this is a great thing to do. I mean, CAI does some of this, particularly nationally as well as locally. But to have the Ombudsman Office list what is already out there and in statute. A lot of people don't like to go read the statutes. I've gotten to the point I can read them because I was in the legislature for 4 years. That's not much experience, but I read a lot of bills and can kind of understand how they're organized. But some people, that's a lot of effort. So I think it's good to do that. And the next one is to publish educational materials. And they're working hard on that. And the Ombudsman Office's similar legislative review, they mentioned how they're going through and developing a lot of this material. And I think the more education we have, the better we are, both as homeowners, as board members, as managers. We can just more we learn about this stuff, the better it makes our life. For instance, and I'll just mention this, I realize this law passed last year, but we had an issue with a portion of our CC&Rs that require 100% of all the owners and others to make a change to that section of CC&Rs. Well, according to the new law passed last year, they can only require 67%. So if we understand the law, it can make things a lot easier for us. So again, then the office is to direct individuals to resource that the office creates. Obviously, if it's there, tell them where it is. And then just a point of clarification is that action by an attorney, it does not create a attorney-client privilege or attorney-client relationship. So these attorneys that are hired up there, they don't have to hold confidential the information that's being disclosed to them. It's not an attorney-client privilege, attorney-client relationship, and perhaps some of the attorneys here can talk more about that. But I think it just frees up those attorneys that they don't have to worry that they're going to have to keep confidential things that are disclosed to them. Next items, we'll go on, is the opinion filing fee is non-refundable. I think there was a point there where people thought they'd get their money back if they didn't get the answer they wanted. Well, that's not the case. You pay that fee and it's paid by that individual. And I think there was some point as well where they could split that fee if the finding was against the other party, that they'd have to split the fee. That was just paid by the individual who files it. Binding arbitration is not required before they get an opinion. So they don't have to go out and do a lot of extra work, but they can ask for an advisory opinion without going through a tremendous amount of work that ends up coming back for another opinion anyway. So they don't need to exhaust all existing procedures. They can ask a question and get some help on it. But the request must specify the contents, specifies contents of the request. So that I think the thing is, it has to specify what the alleged act was, what the impact of that alleged act is. And so they simply have to specify that when they file an issue with the office. So it just clarifies what you need to file with them. One other thing that was also changed, and I don't think I've got it listed. Nope, I don't. And that is that there was a $250 a day fine if the faulting party, if the party is found at default or at fault. That is now, I believe it's maxed at $3,000, or maybe it's 2,000. Anyway, it's maxed out. So it isn't a per day fine.
Max of $5,000 is the
Thank you.
penalty. Yep.
I read that and thought I should have put that in here. I thought, yep, oh well, too late. And then I appreciate this. Tyler, you put this out here that there are 28 total opinions, and some of those opinions addressed multiple questions, multiple legal questions. And so it's interesting here that 57 of those legal questions found no violation of the law, and 12 were in violation of the law. And so far, only owners have filed any opinions, filed to get opinions. No association has gone to the ombudsman office to request an opinion. So far, all of the opinions have been requested by owners. So that's why the chart kind of shows how that works. There has been no finding on the fault of no filing made by an association. And again, I think it's important to remember that these are non-binding. They are simply an opinion by the office of the ombudsman that can help in resolving some issues. But again, if you want real issues solved, you've got to go to court, get a lawyer, and go get some other thing, get it solved there rather than just filing to get an opinion from the office. And then next area has to do with the HOA registry. I will state up front that it is required to file with the state if you are going to file a lien against any of your properties. If you are not going to file any liens, you have no intention of filing a lien, which you never know. I mean, you may end up needing to file a lien. You don't think you will. But it is $95 per association per year, regardless of the size. That's still the same. And if registered, you can't file a lien against any of your properties, any of your association owners. What has changed is the association name and address still required, president's name, telephone number, but their name and telephone number, but the address is no longer required of the president, nor of the manager or management committee, which is the board members. So it's simply the name, and I believe it's the telephone number, name only for the manager and the management committee and the president's name, but that includes the telephone number, contact info. So again, we don't have to disclose the address for all of your board members. Now, I know there's a lot of associations that are putting the address of the management committee in there, or they're creating a special email address or a telephone number that they monitor that's not their personal private number. And as long as there's a way to contact you, that's fine. So if the president wants to create his own email or use the management company's email for his contact info, as long as they monitor it or somebody monitors it, that's the key issue. So I think that's it.
Okay, real quick, Bruce, as we finish up, we have Chris Binning participating, and he is with the Ombudsman's office. And he let us know that there have been a couple of requests for advisory opinions submitted by associations.
Oh,
So
I did.
that's good
Okay,
to know.
didn't know that.
We don't know. I know, Tyler, you would respond to that asking if they are in progress or were they declined. So let's see.
Yeah, he mentioned he just chatted back with me that there's a few that are in progress.
Okay.
So that'll be fun to watch as those opinions come out.
Yeah, and then Monarch Meadows was submitted by the association.
Okay, good to know. Was not aware of that. Thank you.
Excellent.
Okay, Todd.
Thank you. So HB 306, reinvestment fee structure, the legislature this year made a major change, I believe, to the HOA reinvestment fees this year. Basically, it further tightened on how HOAs can charge and use the reinvestment fees. But however, I must say that if you manage or live in a large-scale master planned 500 acres plus or 500 plus residential units, none of these fee caps apply to you. So with that, the new limits on how much an HOA can charge, a 0.5% cap on the property value if your community has capital intensive infrastructure maintenance, which means maintenance on infrastructure facilities the HOA owns, operates, and maintains. So the infrastructure must have a projected useful life of 5 years. You have your community needs road surfacing, and they have parking lots. You have major structural repairs in your community in regards to retaining walls, bridges, or foundations. If you take care of water, sewer, storm drains, you have a clubhouse, swimming pools, pickleball courts, basketball courts, things of that nature, and replacement of big ticket items. So if you have that, essentially entails your capital intensive infrastructure maintenance, and you can only charge 0.5%. However, on top of that, half of that reinvestment fee must be deposited into your reserves with that. So make sure that's a big change. So if you have a reinvestment fee of a certain percent, half of that has to go into your reserve fund. Another limit is a 0.25% cap for low amenity associations. That's comprised of only detached single family homes. And that does not include the following activities to justify a 0.5% reinvestment fee. So if you do regular snow removal to sidewalks, if you perform minor repairs or small equipment replacement, you cannot charge more than a 0.25% of the reinvestment fee. And again, the same with the high intensity infrastructure, half of your reinvestment fee that you collect must be put into your reserve fund. So that's it with the caps and resurfacing. Also a change of this year is that there's a mandatory reporting to the Department of Commerce, and you must register with them, of course, every year, and you must state if you charge one a reinvestment fee or not.
Well done.
Listen, big changes, but fairly simple. I think the biggest concern is what is going to actually be determined a high intensity and a low amenity community.
So for anyone that's had their blood pressure raised during this, I will just share with you that I have not encountered any low amenity associations that will be impacted by this new legislation yet. So if you're single family detached and you had very little to maintain, I have not found any of them that were charging 0.5% or even more than 0.25%. So I think it'll be a very, very rare association that's impacted by this new legislation, although it's good to be aware of.
Okay.
Hey, Quinn, any
Uh,
questions that you've saw?
yes, and I see that you had responded to one, so I will let you do that. The question was, uh, aren't you allowed to have the manager register for the board as long as there is a written agreement for each board member?
Sure, happy to address that. So our position has always been yes. This issue came up to the ombudsman's office. They chimed in with their opinion, and their opinion was that if the board had authorized a manager to put in their contact information in lieu of a board member's personal contact information, that would be acceptable. I know that that's a ubiquitous practice. Most HOAs do it that way. And I just think that the takeaway is make sure that the board has authorized that they've designated the manager to be their point of contact on email and phone if that's their desire.
And Tyler, to clarify one other element of that question, does the written agreement need to be with each board member, or is it a board resolution?
Well, I don't think the statute dictates that. So I think it could happen in a variety of ways. I think it could happen through a contract, a resolution, minutes in a meeting minutes. I think there's a variety of ways to authorize that. I think the key though is to make sure that everyone understands, board and manager, that which phone number and email they want to have on the registry. Anyone else view that differently?
No.
Okay.
One other question that came in, it's circling back to the reinvestment fee. The question is, can it be charged to current owners or just new owners?
Well, so the very nature of a reinvestment fee, it's a fee that's due and payable upon and as a result of a transfer, right? Of a closing or transfer. So it's not a fee that you would put on current owners. How it's applied as between a buyer and a seller on a transaction is really for that buyer and seller to negotiate between themselves.
Well said. Okay, that is all of the question. Well, there was one more that came in and said, if the association does not currently have a reinvestment fee, do you need to amend your CC&Rs? And so there is an answer on there. Yes, if your covenants do not currently include it, you would need to amend to have a reinvestment fee covenant that is then authorizing you to charge the reinvestment fee.
Exactly right. You got to have the agreement or the covenant in place to be able to charge it. Okay. Awesome. Let's dive in and cover the rest of these topics. The first topic that I'm going to cover relates to some additional laws that limit what kind of covenants are valid, what kind of CC&Rs are valid. I had a lot of heartburn over this provision, and we spent a lot of time trying to limit this and contain it, and that was a challenge. In my view, this legislation came out of and I know you're on here, Chris, and with all due respect, it came out of a ombudsman opinion that was incorrect and inaccurate. That opinion expressed that limitations on rules in the current statute also were amounted to limitations on CC&Rs. And that is a very different interpretation than the industry and industry professionals had to that point. But it kind of brought the issue to the forefront with our lawmakers to decide what type of provisions can be in rules and what type of provisions can be in your declaration. And what resulted are some clear standards now that state which type of provisions that a declaration cannot prohibit, that they cannot address. And this is an oversimplification, but it's a fair summary of the issues that are addressed in the legislation. So if you look at the red topics, A declaration cannot prohibit for sale or political signs, flags that are displayed in a window. Okay. Now jump down to the blue section. An HOA can still, by both rule and covenants, adopt reasonable time, place, and manner restrictions on flags, signs, and holiday decor. We could spend an entire hour talking about flags, signs, and you know, political signs, holiday decor, those type of topics. But the big takeaway is be aware that what was limited in the rules is now also limited in a declaration. Same for low water restrictions and drought and park strip conversions, areas that are 8 feet or less. We've known now for several years that we could not restrict those by rule. We also cannot restrict them by the CCNRs. An important topic as well. Many associations were regulating public street parking through their contracts with their members. That is no longer an option. We knew last year that it wasn't an option to do that by rule. It's now not an option to do it by covenant either. Um, Holiday and religious signs have some additional limitations in the declaration. We shouldn't be regulating the content of holiday and religious signs. Security cameras get special protection, and basketball standards on homes that abut a public road get special protection. If those homes abut a private road, they are not protected. So it's definitely an area to look at and to do a deep dive on. Perhaps we can have an article on this devoted to it or a special webinar devoted just to this topic. I just want you to be aware that some of those limitations and rules, not the entire list, has now transferred over to also be a limitation in CCNRs. I'm going to pause there. Quinn, have we seen any questions come in? Usually
Yes.
the topic brings a lot.
There are some. I'm just going to say there are still some questions about reinvestment fee.
Okay.
And so I think we need to get through some of these other issues, and we will come back at the end to touch on the reinvestment fee again.
Okay.
So questions that relate to this, there are a few. So one is, can an HOA require a basketball goal to be lowered when not in use? We have view corridors we are trying to protect.
Okay, well, there was an opinion that just barely came out about that. Again, just remember these are opinions, they're not binding, but take a look at some of the recent ombudsman's opinions that were published where they have gotten into restrictions on basketball hoops and including requirements to lower them to protect view corridors. There's some controversy surrounding whether those opinions should be rendered. One of the jurisdictional limitations for the Ombudsman's office is not to opine as to whether governing documents are reasonable. In my view, some of these recent opinions do venture into that reasonableness standard to analyze that. I don't know that we can say for certain. There's some open questions here about what the limits are on basketball hoop regulations. What we do know is that they're protected if it abuts a public road and they have to be properly installed and maintained. That's what we know for certain.
Yeah, one other thing on view corridors. In Utah, there's no default viewscape easement or right to preserve your view. There are some covenants or in deeds where it is there, but you would have to have that separate covenant in place. So, just because you want it, if there's no covenant, doesn't mean that that I guess that you can necessarily protect that viewscape. So,
Yeah.
Okay. Can an association prohibit cameras if they have to be attached to stucco, which they don't want because it can cause damage? I mean, the HOA does not want that.
All right, so cameras are protected at certain limited areas, immediately adjacent to windows and access and entry points. Okay, so that means that they're not protected on eaves or carports. It's simply windows and access and entry points, and it has to be immediately adjacent. The HOA does not lose its ability to still require that they be installed properly and in a way that doesn't cause damage or that damage be addressed. but we do have to allow them immediately adjacent to those areas, even if they're being affixed to a stucco system. We can dictate how they're affixed to make sure it doesn't cause damage, but we can't limit them.
What about restricting the colors of those cameras?
I don't think we lose any of our architectural control requirements. I would just caution you, make sure that those requirements are reasonable and not applied in a pretextual way to essentially restrict the camera.
Okay. Going to profanity. What are your thoughts of regulating a political sign with the F word on it?
Yeah, so one of the things we negotiated last year is you can still regulate obscene, profane, or commercial messages on signs and flags. So if it has profanity, that's fair game to regulate.
It's also important to look at the definition of political sign, right? I mean, if it's just saying, directing a word against somebody in particular, that's not necessarily a political sign because it has to be directly related to electing somebody or to, against that person or towards an initiative,
A ballot
a
proposition.
ballot,
Yeah.
yeah, ballot proposition. So,
Yeah.
okay, let me go through a couple others. I'm trying to do the topics the same. So, all
I
right, we
see
got a
someone
couple.
asking about street parking. Just to be clear there, the only limitation is on public streets. So if you have an HOA with private streets, nothing is impacted. You can continue to regulate parking on private streets within an HOA.
Okay.
Tyler, maybe
Um,
add in on driveways, right? That they have to use their garages first if there's a rule there, but you have to allow parking on driveways.
That's correct. So parking on driveways, except for these categories that Ryan presented on earlier, also you can require that vehicles be parked in a garage first before you have to honor driveway parking.
okay, well done. Yeah, you guys
You can
addressed.
ignore some of the details on the graphics. The graphics just depicted, I saw a question about that to show that our legislature is limiting our CC&R our provisions.
But hey, using AI to create those, they
Yeah,
don't have extra fingers, so that's an
right.
improvement. Um, what's the interplay with this new statute and the changes to trailers, boats, etc. that was discussed earlier?
Okay, so it's directly related. So the protections on driveway parking now apply not only to rules, but to CC&Rs as well, except for those exceptions that Ryan mentioned, which are motorboats, RVs, utility trailers, special equipment, things like that. So we can always restrict that, and we can still require vehicles be parked in the garage first. But CC&Rs and rules cannot otherwise restrict driveway parking, except for what we've addressed.
Okay, somebody is saying so no on-street parking or no street parking within an HOA can be regulated. I think this is go ahead and do the distinction about private and public streets.
That's exactly right. So you can restrict street parking on a private street. You cannot do that on a public street. You just have to rely on city code enforcement, law enforcement, or some other entity to address public street parking violations or problems. But the HOA cannot get involved in that.
Okay. Um, going through some of the topics, let's go ahead and move on. There's more reinvestment fees. Oh, here's one. With the changes to SB 122, if the plat map shows an area between homes as a private driveway and city utility easement, can the HOA enforce permit and or parking restrictions?
Same rules as to driveways. So if the plat describes it as a driveway, you can restrict driveway parking according to the exceptions and require parking in the garage first. That's still fair game, even if a public utility easement is also running through that same area.
Yeah. And the private driveway, the fact that there's a utility easement running through a private driveway does not convert that to a public driveway, right? It's just, I'm sure many of our yards and different things will have those utility easements running through them.
Okay, I'm going to keep going. I'll let you chat back with some of these folks, but just in the sake of time, we're going to keep cruising along. This is something to be aware of that we can cover relatively quickly. Sometimes the state or a city or somebody wants to come in, and usually it's UDOT, and take over a portion of the HOA's common area property. They're expanding a highway or expanding a road, or they're doing a culvert or something like that. And when HOAs encounter that, it can be difficult because there's other laws that make it difficult to transfer common area. So unless we wanted this to go through the court process of getting a final judgment by a Utah state court, we would have had to go get 67% approval of all the members to work out a deal with UDOT, even if they're paying us fair compensation for taking over that land. This streamlines that process. And it just says you don't have to go get a vote. If there's a legitimate threat of eminent domain to take over HOA property, that the board has authority to negotiate that and transfer that property and skip the requirement to get that 67% vote. That's all that that does. Okay, something to be aware of. For many, many, many years, the Community Association Act has had a provision about the adoption of budgets. And after a board adopts a budget, the members actually had a 45-day window where they could call a special meeting and gather at least 51% of the votes of the ownership and reject the budget. And if they were successful in doing that, by the way, I've never seen it happen. If they were successful in doing that, then the budget would default back to the prior adopted budget from the prior budget year. That provision now applies equally in the Community Association Act and the Condo Act. So just be aware of that, that if you're in a condo, you're subject to that same thing that's existed for many years in the community in a PUD, in an association subject to the Community Association Act. Okay, this is also just a quick change we can address. If you are one of those large master planned communities, again, that's 500 acres or 500 units or more, that the board, the declarant, the developer can get an additional 300 days to turn over the community if they have formed a turnover committee and they're doing things like gathering proxies and requesting nominations. It gives them an extended period of time only in large master planned communities. Okay. Okay, I'm going to pause. Looks like we've got a couple questions that have come in.
Yeah, there are several dealing with
The budget?
well, the signs. So back on the F word, there's a comment about a few years ago, the Supreme Court said the F word was protected speech. So how does that deal with
Yeah.
us in being private communities?
Okay, so HOAs are private corporations. We're not governmental entities. So free speech standards do not apply the same way to private corporations that they do to public agencies and municipalities and the state and the federal government. So it's not, you can't take those free speech rulings and apply them equally to HOAs. Instead, we just have to look to the statutory limitations. And here, the statute says you can regulate profanity.
Okay. There's some budget questions. If a board adopts a budget in January but doesn't have an owner meeting until April and 90 days passed, is that budget going to be effective, or when does it take effect there?
So there's nothing about this legislation that affects the adoption of budgets or the timing of when they go into effect. All that it's doing is saying after it is adopted, there's a 45-day window to reject it. So there's nothing in the statute that addresses things that would otherwise be left to your bylaws or your covenants for budget adoption. So just focus on your specific governing document process for adopting that budget to determine when it applies.
Okay. What about when it's still under declarant control? Can the owners disapprove a budget?
There is no special exception under declarant control. So on its face, this applies to all associations, regardless of who's controlling it. So it's also true. It's been true for years that you have to, under declarant control, hold a meeting every time you change a fee or increase an assessment. So the intent appears to apply to both declarant controlled and post declarant controlled communities.
Okay. Trying to bring them in for different topics. So we've got a few more parking ones. Well, let's see, basketball standard first. Basketball standards that are not fixed to the condo, a standalone basketball standard that can be moved. Is there anything that prevents the association from restricting where the hoop can be placed? For example, has to be by the door and not at the end in the road.
There's no guidance on that. It's just that you can't prohibit them. So I think there's rules to adopt reasonable restrictions on placement and location, things like that.
Okay. Back on a budget, how can we revert back to prior year budget if what is being funded for last year is different from this year?
Well, it's a problem, right? So if 51% of the community rejects a budget and a needed increase, that association has a big problem to address. So the statute doesn't address that. It just says if a majority of the community rejects the budget, it defaults back to the prior year.
Okay. If there is a special meeting, so I'm assuming this one applies to the budget, who pays for, creates, mails, etc., the information related to the special meeting notice?
Typically, that falls on whoever's calling the special meeting. The statute doesn't address it, but there's no obligation if the HOA is not trying to call the special meeting, there's no obligation on their part to fund the event space or the advertisement or the notices that go out. There's certainly nothing stopping them from doing that, but they're not obligated to cover the cost of those mailings for calling that meeting.
Okay. Another sign question. With street parking on public streets and signs, we have a public street with single-family homes on one side. The other side is the side of condo buildings. The single-family homes have placed the sign "Slow Children at Play" in the street to prevent condo residents from parking in front of their homes. Does the HOA have authority to have these signs removed that are placed in the street?
I'm trying to get my head around signs placed in the street. Are
Yeah.
these like
I think
painted?
it's I think it's on, we all drive down the street and they'll have those the signs of the little children out there saying, hey,
Oh,
children at play. And so I think as I read that, that's going to be in the public
in the
street.
public street. Yeah, I
Yeah.
mean, there's no restriction on putting signs in public streets. So if in theory your governing documents allow you to restrict signage in public streets, it's not a provision I've seen, then in theory you could do that. But well, that's pretty particular set of facts. We would just encourage you to reach out to council and work through that one. Okay, Quinn,
When we're
I'm gonna keep moving. If it's all
okay,
right, just
go
just
ahead,
to,
go ahead.
just to hit the rest of these, and if you're good, maybe you can answer some of these in the
Yeah.
chats. Okay, SB 122 also addressed records. This is kind of an intuitive um, legislative provision. It just says that the records of the HOA belong to the HOA. And what this comes out of are complaints coming to lawmakers that some HOAs are unable to obtain their records from their manager, typically their prior property manager. And so I think we've all encountered some HOAs that have experienced frustration with getting records from a management company after a turnover. And this law simply says the records of the HOA belong to them. It does not impose any kind of penalty or process for obtaining those records. It just states the obvious that HOA records are the property of the HOA. Okay, this one's a pretty simple concept as well. We have some communities in our state that fall within the wildland urban interface, basically where uh, suburban areas come up against wildfire areas, wildland areas. And the intent of the statute is to say that the HOA cannot require an owner to keep vegetation in an area that would be defensible space in the event of a wildfire. So we're not going to get into all the nitty gritty, but if you have a community that's right next to a wildfire zone, you might need to be a little more hands off on what kind of trees and shrubbery you require in that immediate zone around the house if an owner wants to eliminate that to make it a little more safe against a wildfire risk. So be aware of that one. All right, this is some changes to federal law. Not all of this goes into effect right away. These provisions kind of phase in throughout the year. But what I want you to be aware of is if you're a condo and you want to be FHA certified, there have been some changes. The 50% owner occupancy requirement has been eliminated. So you could have a higher percentage of rentals and still obtain approval for FHA project approval. The minimum reserve funding requirement, again, this is only for condos that want to be FHA certified. It is not a funding requirement for any other HOA. It's been increased from 10% to 15%. Um, or you can show that you've met the highest funding level from your reserve study that was done within the last 3 years. That's probably a higher benchmark than hitting 15% funding. There's also some insurance requirements. You still have to have 100% replacement cost, but it's easier to document that. The max deductible in a condo that is allowed to still be FHA approved is $50,000 per unit. So if you're in one of those communities that exceeds 50,000, it's not a problem other than you won't be able to be FHA project certified. Okay, and then there's some update requirements to mortgage servicers to verify insurance requirements, and so forth. Just wanted to make you aware that those are some changes at the federal level. All right. We had a statute that addresses nuisances in Utah this year, HB 591. What this statute did is it says we're going to eliminate any common law right to pursue a nuisance violation. So we don't have a lot of time to get into the distinctions between common law and statutory standards. But the big takeaway is you have to rely on the statute for what constitutes a nuisance and what can be enforced in that way. Some examples in the statute include gambling, prostitution, gang activity, unlawful discharge of a firearm, drugs, and party houses. If you're just relying on the statute, this is the type of things that you can enforce. What you would not be able to enforce, that this is a change, anything that's any action or condition that's otherwise lawful, you might not be able to enforce what you previously could under the case law as a nuisance, right? If it's been authorized, approved, licensed, or mandated by a governmental entity, you're not going to be able to rely on a common law standard. And this comes out of some litigation involving gun ranges near neighborhoods where people were relying on common law standards rather than statutory standards to stop these kind of nuisances. The big takeaway for HOAs, and looks like my slide's a little goofed up here, make sure that your CC&Rs have a robust provision because you can still rely on the contract and you can rely on the statute. So your CC&Rs can define what's a nuisance for your community or leave it in the discretion of the board to determine what's a nuisance. And then we're relying on a contract or a statute rather than common law standards that have been developed over years through judicial decisions in the case law. Okay, that covers all of our topics. Let's see, how much time do we have left? We have a few minutes to address some questions.
Yep. Okay, I'm going to present them and then start going on to the other ones. So back on the reinvestment fee, can you collect a reinvestment fee on an inherited property? And then also with it, can you collect it when the property is transferred into a trust?
Okay, so there's some exceptions to reinvestment fee application. If it's done for estate planning purposes, a lot of governing documents exempt that. There's another list of exemptions related to like foreclosures by mortgage servicers and things like that. So you'll want to check your governing documents in particular and the exceptions in the statute because not every single transfer is eligible for a reinvestment fee.
Okay. Also on the reinvestment fee and the 50% requirement, does that apply to large master plan communities?
It does not. If you're a large master plan community, nothing changed with respect to reinvestment fees. There's zero change at all.
Yeah, the change in the statute specifically states, and if you are a master plan, then that provision does not apply. Okay. Any changes made regarding common area taxation?
There's some clarification here. I wouldn't characterize it a change, but we've been working for the last several years to make it clear to county assessors that land that is common area should not be taxed separately from the lots or units within that plat. There are some weird circumstances that come up where an HOA considers it common area, but it's not platted that way, where there have been disputes with county assessors' offices. But generally, if it's platted as common area, or even if you treat it as common area in most counties, it should not receive a separate tax bill. And that's not a change. There's just been some clarification to try to educate county assessors' offices on that.
And on that as well, yeah, legislators are aware of it. We were hopeful last summer they were going to be having a meeting with several of the legislators, and I think even some of the county assessors to talk about this issue, because I think there's 3 different sections in the Utah Code where it addresses this type of taxation. So I was invited to go, and then they canceled, so nothing happened. And what I was told was that's an issue they don't want to address right now.
Yeah.
So, okay. What about profanity? We can regulate on signs. What about verbally?
Uh, in theory, you can regulate conduct if you have a valid rule or governing document provision on that. There's nothing in the statute that addresses verbal expressions of profanity.
Okay. Regarding vegetation removal in WUI area, there's no statutory definition of vegetation. Would this effectively invalidate any minimum tree or shrub planting requirements by design review committee, since an owner can remove vegetation on their property anyway?
I think yes, within those areas, it's going to be broadly applied that any vegetation requirement is going to be viewed with suspicion based on the wording of that statute.
Okay. Administrative setup fee. Is there a cap? Ryan, do you want to talk about that one? Oh, you're muted.
Yep, there we go. There's not a cap. The cap did not pass, but we go back to encouraging people to be reasonable, management companies to be reasonable in those fees. The large discussion was about excessive fees where the cost of doing the work didn't justify the charges. So there is not a cap, but it would be readdressed if it's abused.
That was kind of a hotly contested issue this year. So, okay. Okay. You didn't comment on driveway parking, just public streets. Can we not prohibit parking in driveways either?
Okay, so we did comment a lot on driveway parking, but let me recap it real fast. You cannot restrict operable vehicles in a driveway except if you're requiring that they park in the garage first. If they've already parked in the garage, we have to allow them to park in the driveway if it's an operable vehicle. If it's something like a trailer or a boat or special equipment or an RV or a Sea-Doo or a snowmobile, we can restrict that.
Okay. All right. Somebody else said you mentioned taxation of common area. I've never seen property tax bill on our clubhouse. Great. That's the way
Great.
it should be,
It's
but there
working,
are some that
working right. Yeah.
are being taxed.
I have several HOAs that have had to fight that very issue this year. All of them so far successfully getting that tax bill abated.
Okay. Somebody else on the reinvestment fee, does the 50%, you have to go back and put 50% in? No, it's going forward.
And that starts in May.
Yeah, May 6th is when that takes effect.
Okay, let's do one last question so we can honor the time
Okay, let's
limitation.
see. What about this one? So this is the latest. Sorry if we missed some of the others. There was a lot coming in, and I tried to address some, but couldn't keep up with them all. Okay, with water restrictions, if the city implements a fine for misuse of water, and then they fill a kiddie pool when the city said no, and they assess the HOA a fine, are we required to obtain attorney involvement to assess the homeowner the fine?
I didn't quite follow that one. I was answering
I,
another one.
I
Do you
think,
answer that one?
okay, let me restate that. So if we get water restrictions this year because of drought conditions, and cities implement policy that if you misuse water, they will fine you. If an owner then fills a kiddie pool, which is against the city policy, um, and the city assesses a fine to the HOA rather than that owner, essentially, can the HOA assess the homeowner for that fine? Do they need to get an attorney involved?
I would say, yeah, get an attorney involved because that's a very specific fact pattern that would require looking into your governing documents and your authority and your assessment authority. You- Well, awesome.
Okay.
There's more questions coming in. There's always a lot to discuss. We appreciate your involvement. Thank you so much to the panelists that have helped out today, and thanks to LAC and the membership generally that supported us throughout this legislative session. The last thing I'm just going to say here real quick is if you haven't already, if you would consider asking your associations to donate to support our efforts, we would certainly use the help. It helps to support our lobbying efforts mainly, and events like these. So you can scan this QR code or go onto our website, and there are great programs. A lot of association will donate $1 a door or more to help the cause here and help us to have good laws that balance homeowner rights, boards, association rights, developer rights, and we try to think through that carefully. So thank
And
you so
Tyler,
much. Yes, Bruce.
and if you're not a member of CAI, we encourage you to become
Join.
one.
Absolutely. Join us. Okay. Thank you so much, everybody.